Against Jepsen and others.
Lord Burrows will explain the court's judgment.
This case is concerned with rent repayment orders. They are an important sanction against rogue landlords who commit certain types of offence, such as being in control or management of a house in multiple occupation that is unlicensed. A tenant can apply for a rent repayment order, as can a local housing authority which has provided universal credit in respect of rent under a tenancy. The question raised in this appeal is whether a rent repayment order can be made against a person who the law describes as a superior landlord. The relevant property in this case was a flat in London. Mr Rakusen granted a tenancy of the flat to Kensington Property Investment Group Limited, KPIG. Under licence agreements, KPIG then granted the right to occupy a room in the flat in return for a fee to each of Michael Jepsen, Roland Murphy and Stuart MacArthur. They can be referred to as tenants because a licensee counts as a tenant under the relevant legislation. So on the facts of this case, in relation to those tenants, Mr Rakusen was the superior landlord and KPIG was the immediate landlord. As the flat was in multiple occupation, it was required to be licensed under the Housing Act 2004, but no licence was ever granted by the local housing authority. The tenants, Messrs Jepsen, Murphy and MacArthur, therefore sought rent repayment orders totalling £26,140 against Mr Rakusen, the superior landlord. They based their claim on the ground that Mr Rakusen had committed an offence of being in control or management of a house in multiple occupation without a licence. Mr Rakusen denied that he had committed such an offence, but in any event sought to strike out the claims, arguing that a rent repayment order could not be made against him because, in relation to the tenant seeking the rent repayment orders, he was a superior landlord. The First-tier Tribunal decided that it could make a rent repayment order against Mr Rakusen as a superior landlord, and the Upper Tribunal agreed. But the Court of Appeal reached the opposite conclusion and held that a rent repayment order could not be made against a superior landlord. The tenants now appeal to the Supreme Court. The Supreme Court unanimously dismisses the tenants' appeal. The judgment is given by Lord Briggs and myself, with whom Lord Lloyd Jones, Lord Kitchen and Lord Richards agree. The Supreme Court reasons that a straightforward interpretation of the central statutory provision in question, which is section 40 subsection 2 of the Housing and Planning Act 2016, means that the relevant landlord is the immediate landlord under the tenancy that generates the rent. Where it is a tenant seeking a rent repayment order, as on the facts of this case, the landlord is required to pay back the rent that the landlord has received to the tenant who paid it. It's artificial to interpret a landlord as including a superior landlord higher up the chain of tenancies than the immediate landlord under the tenancy which generates the relevant rent. Although the word pay rather than repay is used in section 42b, where it is a local housing authority that is seeking a rent repayment order, that does not undermine the focus on the rent payable under the direct relationship between the tenant and the landlord. This is not least because universal credit is paid by central government, not by the local housing authority. It would therefore have been inappropriate to use the word repay in respect of a rent repayment order in favour of a local housing authority. The Court considers that 7 additional interpretative factors on balance support, or at least are consistent with that straightforward interpretation. First, when rent repayment orders were originally introduced by the Housing Act 2004, they indisputably could not be made against a superior landlord. There is no indication, including in pre-legislative materials, that a purpose was to change this when the legislative scheme was revised in 2016. Secondly, it would appear that a purpose of rent repayment orders was to restrict such orders to those who directly benefit from the payment of rent, that is, immediate landlords. Thirdly, there is a range of other sanctions available to combat rogue landlords. These include fines, civil penalties, and banning orders. If these are thought to be inadequate, any reform is a matter for Parliament and cannot be achieved through a distorted interpretation of the relevant provisions in the 2016 Act. Fourthly, allowing a rent repayment order to be made against a superior landlord could create complexity as to how much should be repaid, by whom and to whom, where there is a chain involving numerous tenancies. Fifthly, the straightforward interpretation may also be regarded as supported by other statutory provisions. For example, for certain offences under the Protection for Eviction Act 1977, the definition of landlord was expressly extended to include any superior landlord, but this was not done in the provisions relating to rent repayment orders. Sixthly, taken as a whole, the pre-legislative materials are consistent with the straightforward interpretation that rent repayment orders are not available against a superior landlord. And finally, the straightforward interpretation is supported by the principle that if there were any doubt as to whether a statutory provision imposes a penalty, the doubt should be resolved in favour of not imposing the penalty. The conclusion reached is that those additional relevant interpretative factors, on balance, support or at least are consistent with the straightforward interpretation of Section 40, subsection 2. Although not always true in the law, in this case, the simple answer to the question posed is also the correct answer. A rent repayment order cannot be made against a superior landlord. The appeal is therefore dismissed.
The court is now adjourned.